Good morning, Mr. Adams.
Good morning.
How are you?
Good, fine.
Good. I think we've got everyone we need. Ms. Rivers, you ready? Okay, let's go on the record in State versus Watson and Scott. It is Wednesday, the 24th, a little before 9:30. We've got our prosecutors here. Mr. Watson is here with Mr. Francis, and we have Ms. Scott here with Mr. Adams, and we now have all our jurors. We had one who was held up for some reason, bad weather, traffic, et cetera, but we've got everyone here. Mr. Abadi, anything we need to discuss before the jurors come out?
There you go.
What is the latest about the witness from Henry County?
I think we have worked out a Zoom link. It'll probably be the second of this week, call today.
Okay, so they will patch into our Zoom that is set up, or how is that gonna work?
That's my understanding, yes, sure.
Okay, and it will say just something like Henry County, or it's not a locked Zoom. They can get in if they've got the link.
Yes.
Okay, all right. We'll just need to make sure that who is the person?
Mr. Austin?
That Mr. Austin isn't listening in to testimony before. So I guess I can put them in a waiting room if I see them, but maybe your team will know when they're trying to connect.
Yes.
I just want to maintain the rule of sequestration.
Yes,
All right, so that's Mr. Austin. Otherwise, state's good to go.
Yes, Your Honor.
All right. Mr. Francis, anything on behalf of Mr. Watson at this time?
Mr. Watson has something.
All right, Mr. Watson, if you can stay seated. I just need to be able to see you, so maybe we can, you mind putting the monitor flat? Slide it that way. That works. All right, I can see Mr. Watson. What's going on, Mr. Watson?
I would like to have my attorney removed from my case. I don't feel comfortable going to trial with this attorney. I
Okay,
would like to have him removed. I would like another appointed attorney, or time to have to get my own paid lawyer.
all right. Why is it that you think it would be a smart move on your behalf to have Mr. Francis not represent you anymore?
Sir, I just feel like he's not working with me. I feel like he's not working with me. I feel like he don't have faith in my case. Anything, sir.
Okay. Are there steps that you think he should have taken, witnesses he should be finding that he's not able to find? Or is it more a disagreement about strategy? He might be encouraging you to go in one direction and you want to go in a different direction.
Some in that area, sir.
Okay, so it happens that clients and their lawyers disagree. Mr. Francis has been practicing criminal defense law longer than you've been alive. He's probably told you that already. I know him as a former adversary. I used to be a prosecutor and had cases where Mr. Francis was the very fierce advocate for the defendants I was prosecuting. I have had Mr. Francis try cases in front of me since I've been a judge. And I have found him to be very effective. In fact, his last trial, it was two defendants, and one guy got convicted of murder and another guy got acquitted. And that was Mr. Francis's client. So if you're feeling frustrated, my sense is, and I don't want you to go into private conversations you have with your lawyer. Those are appropriately confidential. If you're feeling frustrated, it may have more to do with the unfortunate set of facts of your case. When Mr. Francis worked his magic, and it wasn't magic, it was hard work on his part and good advocacy to get the acquittal in that other case. It was a very different set of facts. His client was basically along for a ride, and someone gets out of a car and shoots someone and gets back in the car. And the state was prosecuting Mr. Francis's client for the murder as well. And the jury said, we just don't see the connection. You've got a different case, and there's some facts I think I'm going to hear, more importantly, the jury's going to hear with these phone calls and whatnot, that don't give Mr. Francis a whole lot of wiggle room. And so if you hear him saying, maybe you should think about working the case out, I don't hear that as Mr. Francis is lazy or uninformed, or most importantly, doesn't have your best interests at mind. I have not known Mr. Francis ever to be anything other than passionate about his client. Whether he likes his client or not, that's not the issue. He knows what his job is in this process. And so I understand your frustration, but unless you can point me to things that you've seen during this trial that I have somehow missed, that make you think that Mr. Francis is somehow impaired in his performance, it's too late in the process for us to switch. So you would have two options. You could represent yourself, which I'll try to talk you out of because that's a terrible idea. But you have an absolute right to represent yourself. I can't stop you from doing it, but I can try to persuade you not to. Or you can continue to move forward with these two good lawyers working on your behalf. Let me say one more thing, and then I want to hear from you because you raised this important issue. One thing that may have led you to think, gosh, what's Mr. Francis doing, is that he hasn't asked a whole lot of questions of the first few witnesses who came in. And then Mr. Dark has done some of the questioning of the subsequent witnesses. I'll point out that Mr. Adams, who is even more experienced than Mr. Francis, hasn't been asking a lot of questions either, because these first few witnesses didn't have anything to say about you or Miss Scott. You know, the police who respond simply say there were bullet holes in a window, or there was this person who was bleeding. And no one's saying, and I think Miss Scott had something to do with it, or Pond had something to do with it. And so one defense approach is, why would I ask a question of this witness? This witness doesn't say anything about my client. And so I see that all the time, is that you keep a low profile. You don't want to try to pick a fight and look like you're acting like you're covering something up. With all those officers who testified, they had zero to say about you or Ms. Scott. And so it didn't surprise me at all that Mr. Francis and Mr. Adams didn't have any questions to ask. What are you going to ask? You don't know my client. That's right. I don't know your client. Okay. And you move on. We're going to be hearing from some witnesses soon who I think make it more complicated for you or Ms. Scott. And I would then start to be a little confused if Mr. Francis or Mr. Dark, his law partner in this process, didn't start asking more questions, like you saw Mr. Dark do when Mr. June was testifying. And these lawyers who've got the experience are deciding on your behalf who's going to handle which witness, whether it's Mr. Dark or Mr. Francis. But my sense is, and Mr. Francis can correct me if I'm wrong, he's actually running the show and deciding where Mr. Dark is going to assist and where not, because Mr. Francis is the senior of the two. But I won't ever tell those two lawyers how to do things. But I'll tell you that I've seen effective, as in meaningful, representation on your behalf since Mr. Francis has been involved. I'm just giving you my view, but I want to make sure you understand your two choices. You can move forward with these two good lawyers, or you can say, I don't want them to represent me anymore. I'm going to ask them to stay here, so they'll sit at the table, but then you are the lawyer. So you'll decide whether you want to ask a witness questions, and you'll decide what jury charges to give and all that kind of stuff. But we're not going to stop the trial now to find a new lawyer, because that lawyer would understandably say, man, I don't even know Mr. Watson. I need to look at the discovery. But we're underway. So if you're asking for a continuance, I'm denying that motion. I can't deny your request to represent yourself. We'd have to have a longer conversation, which we do in a few minutes, where I'd try to talk you out of it. But we're not going to delay the trial. So option one is move forward with Mr. Francis and Mr. Dark. And then option two is Mr. Watson fly solo, and you are your own lawyer. Do you want to talk to these two about it for a sec, or do you know what you want to do?
I would just move forward, sir.
With these lawyers?
Yes, sir.
Okay.
Let me tell you what he told me. Can we talk for a minute? Because Mr. Abadi mentioned something to me while you were talking to the client.
Sure. As in, you want to go back to
Just
talk?
a few minutes.
Okay, I'll give you about two.
That's fine.
Okay. Hello, Miss Singleton.
Oh, shit. Okay.
Who is your first witness?
Investigator Spurl
Sproul.
and
Okay.
I think I have on the list, Spurley.
We've got Sproul, Sergeant Sproul. You promoted a lot of people on here. I work for a body. I'll be Chief Justice McBurney. Will you, since they sometimes take these bizarre bathroom breaks, let them know, 2 minutes.
Yeah, she just gonna listen to the call. Once she listens to the call, and then yes, she recognizes me, then we're good enough, and she can testify. But I'm not gonna put something up from school. I'm flying by. I can't do it with her.
Did they say they were good to go? Okay. Did the guy who came in late say why he came in late? Just came in late. All right. Oh, it was terrible. Michelle was saying she had to take all sorts of crazy surface streets and all that, so.
Wow, 6 is still opposite.
I was in dreamland at 6. Can you fish them out, please? Ms. Singleton, are you observing or you have something else I can help with? You're welcome to be here all day long if you want. Just want to make sure you didn't feel stuck.
I'm observing.
Okay.
They could give you more. They're asking him not. You understand? I don't think he will. You understand?
Yeah.
Okay, so we got to go to the podium. Okay.
Ms. Jones-Connor, do you know where Mr. Abadi is?
Yeah, sure, right outside.
Okay,
Right now, I'm sorry.
so our jurors are, we're coming up to the podium.
Yeah, based on what I was non-negotiable.
All right, well, let's get back on the record.
Okay.
Mr. Francis, tell me what's going on.
Well, in the interim, as you were speaking to the client, to Mr. Watson, Mr. Abadi indicated that they would be willing to allow him to go non-negotiated, and they would cap it at their current offer, which is 40 to serve 30. We've explained to Mr. Watson, it took us a little extra time because we wanted to be crystal clear that Your Honor can sentence him as he sees fit when you go non-negotiated, and you cannot withdraw it. You walk out of here today with that sentence.
Although I am limited by whatever charges the state's going forward on. So if there's not a murder count in there, I can't suddenly pull life as to the murder out of thin air.
Is my understanding is that the murder will be reduced to voluntary manslaughter.
Okay.
So there's no life sentence attached to that. However, there is a life sentence attached to armed robbery. This is not a mandatory.
Right.
Mandatory life sentence. So we wanted to explain that to him, and he has indicated to me, I believe, that he has a recommendation he'd like to make, and he would like to enter his plea non-negotiated and make that recommendation to Your Honor.
All right. So, Mr. Watson, we can do that. And I will certainly listen to your recommendation. And it may be Mr. Francis has a supporting recommendation that would be, well, if you're not real comfortable with Mr. Watson's, here's another view of it. And then, of course, I'll hear from either Mr. Abadi or Ms. Jones-Connor as to the state's recommendation, although that shouldn't be a surprise to you because it sounds like they'll be recommending a sentence of 40 years to serve 30 with 10 years on probation. If that were to shift, then they would have changed something. It sounds like they've represented they wouldn't. That would be the one way you could back out of this, is if all of a sudden they hear something that makes them say, no, now we're recommending 35 years or 31 years. But if they stick with the 40 to serve 30 recommendation, then whatever sentence I give you, whether I give you 10 years or I give you 50 years, you're stuck with that sentence in the same way you would if you went to trial and a jury found you guilty. You don't get a back out of anything. I would then sentence you consistent with the verdict, but ultimately with the sentence that I think is reasonable and appropriate given whatever you were convicted of. Does that make sense?
Makes sense.
Okay. So is Mr. Francis correct that what you would like to do now is enter what we call a non-negotiated plea where you and your lawyer are going to recommend one sentence? We know what the state's going to recommend, that 40 to do 30.
Yes, sir.
That's what you want to do rather than go forward, because we got our 14 jurors right here and the state's witnesses are ready. We could keep going forward with your trial. You'd rather stop the trial and enter a plea?
Yes, sir.
Okay. You understand that if I accept your plea, which I probably will, and then sentence you, if you're unhappy with the sentence, number one, you do not get to withdraw it. But number two, you don't get to say, that was interesting. Bring the jurors back in. Let's keep going with trial. Understand that that will not happen.
Yes, sir.
Okay. Mr. Francis, have you had enough time to speak with Mr. Watson about the pros and cons of going forward with a plea
Yes, sure.
and the rights that he'd be giving up? In other words, continuing with the trial, the right to an appeal should there be a guilty verdict, and the ability to present his own case should there be witnesses that you and he decide you wanted to call.
Yes, Your Honor, we went through those rights yesterday.
Okay, and they'll be covered more thoroughly by one of the prosecutors if we go forward with the plea. All right, well, that's something we should do right now because we've got jurors who are anxious to get back in here to continue with their service. I would like for us to fill out one of those forms just for thoroughness, but what I'd like to do is have you do that after. We're going to do the verbal or oral part of things now. And then I suspect we're going to need to have a conversation with Ms. Scott and her lawyer should Mr. Watson's plea go through. And when we're doing that, you and Mr. Watson could complete the plea form. And if there are any issues, we'll get that on the record. And we'll certainly get on the record his verification of the signature and your verification of the signature.
Yes, Your Honor.
Mr. Abadi, will you or Ms. Jones-Connor be handling the plea? Okay. Are you prepared to go forward?
Yes.
All right. Mr. Watson, in a moment, Mr. Abadi is going to put you under oath. So you're going to have to raise your right hand and swear to tell the truth. Once you're under oath, it's important that you answer all of his questions and mine truthfully and completely. If at any point someone says something that you don't understand or is different from what you were expecting, let Mr. Francis know so that we can talk about it. It may be that you two need to talk privately. We'll make that happen. It may just be like, hey, I didn't understand what that word meant, or that's different from what we were talking about, and we'll work through that. Will you let me know if you're confused by anything or it's not going the way you thought it was going to go?
Yes, sir.
All right. When you're ready, Mr. Abadi.
We solemnly swear in further testimony of the legal matters in before this court. We truth the whole truth, nothing but the truth, sir.
I do.
Raise your hand now. Could you please state the true, correct, and legal name for the record?
Illegal name?
Your legal name.
Legal name?
Like on your birth certificate.
Emmanuel Daquan Watts.
And Mr. Watson, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you take on a daily basis or regularly that you have not taken today that will affect your ability to understand what we're doing with this plea?
No.
How old are you, sir, and how far did you go in school?
19 into 11th grade.
Great, okay. And sir, are you able to read, write, and understand the English language?
Yes.
Okay. And do you understand that you are charged with the following offenses in indictment number 21 SC 178032? Count 1, murder, counts 2 and 3, both felony murder charges. Count 4, aggravated assault with a deadly weapon. Count 5, criminal damage to property in the first degree. Count 6, possession of firearm with a conditional felony. Count 7, armed robbery. Count 9, aggravated assault with a deadly weapon. And count 10, possession of firearm during the commission of a felony. You understand those charges in the indictment that you're charged with?
Yes.
And do you understand from speaking with your counsel that the negotiations with your attorney over the last several weeks and into this week and today, the state is prepared to reduce counts 1 through 3, the murder and felony murder counts, to voluntary manslaughter?
Yes.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive jury trial.
Yes.
And have you had an opportunity to go over all the rights that you're waiving by entering plea here today with your counsel, Mr. Dark and Mr. Francis?
Yes.
And do you need any additional time to discuss any of the factual issues or anything in regards to the plea with either Mr. Dark or Mr. Francis?
No.
And are you satisfied at this time with the services they both have provided you?
Yes.
And Mr. Francis, do you waive formal reading of the indictment?
Yes.
And do you also waive any and all defects in the indictment, including any with respect to your client's name for purposes of this plea?
Yes.
And Mr. Watson, has your attorney advised you of the minimum and maximum sentence for each charge you're pleading guilty to?
Yes.
Did he advise you that for the reduced counts of voluntary manslaughter, so counts 1 through 3, the minimum is 1 year, the maximum being 20 years?
Yes.
Be advised that for count 4, aggravated assault with a deadly weapon, the minimum is 1 year, the maximum is 20 years.
Yes.
As to count 5, criminal damage to property in the first degree, did he advise you that the minimum is 1 year and the maximum is 10 years?
Yes.
Right? And then as to count 6, possession of a firearm with the commission of a felony, did he advise that the minimum you can receive is 5 years for that? You have to receive 5 years as it relates to that count. That count could be suspended, probated, or served in prison.
Yes.
And count 7, armed robbery, did he advise that the minimum is 10 years, or if the sentence is 10 to 20, or life?
Yes.
And as it relates to counts 9 and 10, 9 being another count of aggravated assault with a deadly weapon, that the minimum is 1 year, the maximum is 20 years for that count as well.
Yes.
And lastly, the count 10, additional count of possession of firearm with the commission of felony, that he advised we just talked about. It's a 5-year sentence, but it can be suspended, probated, or served in prison.
Yes.
Do you have any questions about any of the minimum or maximum sentences that we just discussed here today?
No.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts, sir?
Yes.
Do you also understand that you waive any and all defenses by entering the plea of guilty here today?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you, or court appointed if you were unable to afford an attorney for the trial of your case. Do you understand you waive the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after a trial? You understand that by pleading guilty here today, you're giving up or waiving all of those rights?
Yes.
Has anyone, sir, forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty, sir?
Yes.
And how do you plead to indict counts in indictment number 21 SC 178032, counts 1, 2, and 3, which were count 1 was murder, and counts 2 and 3 are felony murder, now reduced to voluntary manslaughter under OCGA 16-5-2.
Yes.
And how do you plead to count 4, aggravated assault with a deadly weapon?
Yes.
And you plead to count 5, criminal damage to property in the first degree.
Yes.
And you plead to count 6, possession of a firearm in the commission of felony.
Yes.
And you plead to count 7, armed robbery.
Yes.
And as it relates to count 9, an additional aggravated assault with a deadly weapon charge.
Yes.
And lastly, count 10, possession of a firearm in the commission of felony for the offense of unobstructed access.
Yes.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you, sir?
Yes.
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Lastly, do you understand that you only have 4 years from today for a felony charge to file what's called a habeas corpus petition challenging your guilty plea? Do you understand that?
Yes.
And during the times that you've been able to speak with Mr. Dark and Mr. Francis, did they go over what a habeas corpus petition was, and did you understand all the ins and outs of it?
Yes.
Do you have any questions at this point as it remains to a habeas corpus petition or anything in regards to your plea?
No.
Governor, had this case continued into day 3 of the trial, the state would continue to prove beyond a reasonable doubt that the defendant on October 19th of 2020, earlier in the morning, came to Building 10, specifically Apartment 10A, where Spencer June lives with his significant other, Miss Eva Jones, also known as Miss Rita. On that morning, Mr. June was attempting to enter into his apartment, and at that time, the defendant, along with an unidentified co-conspirator, held Mr. June at gunpoint and demanded that he hand over the items and any belongings that he had in regards to property or anything of value. what the testimony was and what the evidence showed was that while Mr. June was held at gunpoint by the unidentified co-conspirator, the defendant, Mr. Emmanuel Watson, went through the pockets of Mr. June, and as he testified to yesterday, his wallet and the firearm that he had on his left side was removed from his pants, and as a tussle, some sort of conflict continued. At that point, both defendants, Emmanuel Watson and the unidentified co-conspirator, fled from building 10 or apartment 10A, where Mr. June resided. Mr. June testified and told police back in October of 2020 that he then attempted to run after both Mr. Watson and the young male that he didn't know. At that time, as he was running, when both defendants, his testimony and what he told Detective Malone, began to fire shots at him, which he luckily was not shot. He stopped his pursuit of Mr. Watson and his co-conspirator. At that point, Your Honor, Mr. June went back to his house. What the evidence was shown is that early the next morning on October 20th, 2020, at approximately 5:30 a.m., the defendant, Emmanuel Watson, came back to the area of apartment 10A, came from his apartment, which was almost directly behind building 10. He lived in building 15 with his sister, Jeffriana Alford, which is Jeffruna, and Miss Shaquille Scott, also known as Miss Red. He was living with both of them, staying with both of them. When he returned to the area, the back of apartment 10A, he began to open fire into the back of the apartment. As he did so with a rifle, he hit Miss Rita Anna Jones multiple times, head and torso, and her legs and all over the body, causing her to ultimately die from her injuries that she received from the gunshots. As 911 was called, the investigation ensued. The evidence showed that Detective Malone began to interview and canvass the area of 532 Cleveland Avenue, which is here in Fulton County, Your Honor, where the shooting and armed robbery occurred. During that time, he was able to locate Elijah Hunter as well as Mr. Austin Robinson. In doing so, they were able to describe together the armed robbery that they became aware of, and then the shooting that Mr. Austin actually heard from his home. Immediately looked out the window and saw a young black male leaving the area going towards apartment 15L with a rifle in hand, Your Honor. Through the investigation, Detective Malone was able to determine the occupants, as described, Ms. Alford, Ms. Scott, and her juvenile brother, Emmanuel Watson, of Ms. Alford. And in doing so, he was able to determine that Ms. Scott was in custody starting October 11th of 2020. He began to listen to her jail calls that Ms. Scott had made through her stay, beginning with calls that started on October 20th, the day of the shooting. In doing so, he located a call where Scott was talking to a male, which she referenced as Jeffriana's brother. And at that time, Jeffriana's brother, who the evidence would show is the defendant, Emmanuel Watson, began to describe, he was looking outside, crime scene tape, that he had just shot up June's apartment, and that somebody was hit, that he thought it was funny, somebody had been shot, and began to laugh and reenact the sounds that were made as the rifle was fired into the home of Miss Jones and Mr. June. The Detective Malone continued to listen to jail calls. He was able to locate calls on the 17th and 18th, where Ms. Scott and Mr. Watson planned together the attempted armed robbery or the armed robbery of Mr. June, but in the hopes of getting way more items and things of value as it relates to the armed robbery. Detective Malone was able to locate a call that after after the armed robbery occurred, the defendant described to Ms. Scott that he followed through with the armed robbery, but he made a key mistake and that was bringing somebody who didn't know what he was doing. As he backed up and continued to listen to calls, he was able to further identify the defendant through things that he said as it relates to his family members and Ms. Scott. And also it was clear that they were in a romantic relationship at the same time that she was also in a relationship with Mr. Watson's sister, Jeffriana Alfred. So had the case proceeded to continue to trial, that's what the evidence would have shown beyond a reasonable doubt. In my review of the defendant's criminal history, the time of his arrest, he was an SB 40. So his felony record is limited. He does have a pretty decent juvenile criminal history, which stems from aggravated assault, aggravated battery, things of that nature, where he had been in shootouts with other members of the community in the Cleveland Avenue area. He also was charged with witness tampering in a case that involved Miss Scott, I believe it's her brother, or Margell Scott, her son, I apologize, who was being tried for murder. Mr. Francis was actually one of the lawyers on that case, where he was accused of threatening one of the witnesses who identified one of the four co-defendants in that case. There was video surveillance of that nature, but that was handled here with our juvenile court. He does have several incidents in the jail, which is not uncommon based on the conditions of the jail, but.
And how long he's been there.
Yes, that involve stabbing, shankings, and things of that nature. The state's recommendation globally is 40 years to serve, 30 years with the balance to be on probation. The state would recommend, as it relates to count 7, the armed robbery, 20 years to serve. And then as it relates to the reduced count 1 murders being reduced to voluntary manslaughter, it would be 20 years to serve, 10 years with the balance to be on, the balance of 10 years to be on probation. And then the remaining counts that are left to run concurrent or consecutive suspended as it relates to firearms charges. But it would be the state's contention that counts 2 and 3 would vacate by operation of law. Count 4 will merge with count 1. Count 5, 10 years to serve concurrent with the global sentence recommended by the state. Count 6 would be 5 years consecutive suspended. Count 9, the aggravated assault deadly weapon that relates to day 4 with suspension June, 20 years to serve concurrent, and then count 10, 5 years consecutive.
All right. Do you have any victim impact information from either Mr. June, who we did hear from extensively yesterday, or from any of Ms. Jones's family?
So we've spoken to, not to present to the board, everyone was told about the possibility of a plea, and they were in support of the plea, mainly due to the defendant's age. They understood why a reduced recommendation was going to be provided to the board, and they were satisfied with the state's recommendation. I would have made clear that the recommendation is being made by the state, not anything to do with the evidence. The evidence is, in my opinion, incredibly strong as it relates to cases that at least that I have tried and been able to be a part of. I would say that Mr. Francis's advocacy for his client is the only reason he's being provided this deal. I respect him professionally, and the recommendations that he had made as it relates to the defendant and his, I want to say, upbringing, some of the challenges that he faced as he grew up in households that he jumped from, is the only reason the state has agreed to reduce the sentence based on, Mr. Francis kind of hanging his neck out on this defendant.
So you don't think, thank you for sharing that. You don't think that Mr. June is going to be surprised or dismayed that this is the way the case is working out?
Now, we spoke to him last night and it indicated that there was a possibility that there would be a plea. He was neutral about it.
Okay. Any conditions on the 10 years of probation?
I stay away from Cleveland Avenue area and maintain neighborhood employment.
Okay.
And obviously, retire, that would be by law.
Right. Okay.
With Adam, I want to thank you for your patience. It's actually been a pleasure working for Mr. Watson. I've appreciated working for Mr. Watson. As
Even though he tried to fire you.
right.
Comes with the territory.
Comes with the territory. But I can say this, Mr. Watson and I had detailed conversations about the law. I actually printed out a copy of the jury charges for him, and we went through it. And we actually talked about the technical application of jury charge 13270, which is corroboration of defendant's statement. And I explained to him in detail what our defense would be, is that the state has to have corroboration of your statement. Now, but we went into details about the state, the jury charges doesn't really define what that corroboration has to be, and it's going to be up to the state. And that's where we get hung up. But I found that he understood all the law that we went through. And anybody at this age and with this background that can understand that means that there's a possibility, there's a chance. And he's got family support. Y'all stand up. And they've been a pleasure to work with. And so, and one of them may want to speak, I'm not sure.
Okay.
So now what he wants me to ask the court for is a sentence of 30 to serve 13. Is that correct, Mr. Watson?
Yes, sir.
And I wrote it down here is we had asked for 20 to serve 13 on count 1, reduced to voluntary manslaughter. 10 years probation on count 5, criminal damage to property, consecutive to count 1, count 7, the armed robbery, 13 years to serve, and the count 6 and count 10, 5 years consecutive suspended because they have to be consecutive. I've explained to him that sentencing is totally in your discretion. And he understands that. And I want to make sure that he understands that. But I think given his age, given the influences that he was under, he was in a sexual relationship with someone much older than him. And he believed that he was in love with that person. And so he took measures totally wrong, heinous, abhorrent, objectionable. But it was a culmination of what he had come from and what he had come through. That's not an excuse. He's accepting responsibility. But I don't believe that, that he's got a chance. That's all I want to say is that he's got a chance. So I hope that you fashion a sentence that would give him the opportunity to prove that he can rehabilitate himself. Give the Department of Corrections the opportunity to watch him grow and see whether he's worthy of being paroled. And so, Mama, you want to say something? You okay? Okay.
We're good?
We're good.
Okay.
We're good.
So, Mr. Watson, you have a right to say something if you want to. You don't have to say anything at all. Mr. Francis helped me understand a whole bunch about your situation. I'm sure it would take days to better educate me on what your childhood was like and things you went through, opportunities you didn't have. But I don't want to rely only on Mr. Francis if there's something that you think I ought to hear beyond what he shared.
I think I gotta say one thing, but it's only one word, sir. All I need is a chance. Just a chance, sir.
Okay. Well, thank you. Mr. Watson, I find there's a factual basis for your plea. I've heard a bunch of it during trial. We didn't get to the parts that most directly connect you to what went down. I think that was coming up through witnesses and in particular phone calls that you and Ms. Scott had. But I certainly saw and heard enough from Mr. June to see what the consequences were of the actions that you took on the 19th and the 20th of October, a long time ago, 3.5 years ago. But I do think there's a factual basis for each of the counts to which you're pleading guilty. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, but you've decided after a whole lot of conversation with family members, with lawyers, that a plea is a better route for you than going all the way through with the trial. Do you agree with that?
Yes, sir.
And a knowing plea simply means you've understood all the things Mr. Abate talked about and that Mr. Francis mentioned. Do you agree with that?
Yes, sir.
I do too. Mr. Watson, there's nothing that excuses what happened, but I do think there are things that explain it. I often wonder, as I look at a defendant charged with something as serious as this, what were you thinking? How could you do this? And it makes less and less sense the older and older the defendant is. If I got a 40-year-old guy sitting there who shot someone point blank in the head, but you're 40, what were you thinking? And it's not about chances by then. You're a grown man or woman, and you decided that that person's life wasn't worth the drugs it was about or the relationship or whatever. With you, I'm dealing with the saddest of situations. Were you 16 at the time?
Yes, sir.
So I've got a 16-year-old. He's a knucklehead, but he has had what you didn't, which is chances. He was born in a different zip code. He's gone to different schools. And so he's not smarter than you. He's not stronger than you, but he's had a different set of chances that you didn't. And again, that does not excuse what happened. It certainly doesn't bring Ms. Jones back. You saw Mr. June suffering. Talk about a grown man, 60-year-old guy crying on the stand because of what you did. And he'll never be made whole. This will bring him some closure. But it's tough when we in the criminal justice system are confronted with someone in your situation, where I'm sure you'd do it differently if you were given the chance, but you weren't given a chance. And there you were, maybe living part-time in Pavilion Place, and looking around at who your influences were. They may not have been folks who had your best interests in mind. And if they did, they may not have been able to be present in your life enough because they're holding down 3 jobs to try to support the rest of the family, or someone's locked up, or someone's shot. And it leaves young men like you with not a lot of opportunities. And of course, someone who's very, very strictly law and order would say, well, you know what? There were choices. There was the choice of not pulling a trigger. There was a choice of, after having made the big mistake of taking Mr. June's stuff, just walking away from it and not going to that next step. And it's that next step, obviously, that makes this so much more serious. We deal with armed robberies all the time, and they're serious. But now we're dealing with a murder. Someone was killed without justification. So not an easy way out of this for you. I think you recognize that. And I appreciate the recommendation that you've made through Mr. Francis. I think you can appreciate why all of us, and me in particular, as the judge who has to sentence you, why we're taking this so very seriously. And I need to be thoughtful about giving you that chance, because I need to believe that the Emmanuel Watson who emerges at the end of this process, because there is for you an end. That's one difference. If you went to trial and were found guilty, I could probably structure the sentence in a way that the end would be you leave prison in a pine box. But that's not going to happen. You're going to have some number of years you're going to need to serve, and given your age, if you can keep your way out of trouble in prison, you're going to get out, and you're going to be able to hug and hold those people who've been here for you throughout the trial. But there's clearly a price to pay for what happened. We don't just erase it because you said you're sorry, which of course you didn't say. You just said you want another chance. But here's where we are. I need you, Mr. Abate, to sign the indictment again, so we can get on the indictment Mr. Watson's guilty plea. And then if you'll get it to Mr. Francis and Mr. Watson, we'll get you guys to sign that, and then I will pronounce sentence. Thank you, sir. Appreciate it. All right. Mr. Watson, I am going to sentence you on count 1, which has been reduced to got to structure it differently. I'm sorry, Ms. Nelson. I'm going to start your sentence with count 7, which is the armed robbery. And I'm going to sentence you in that case to 20 years, in that count to 20 years. Count 1, which is voluntary manslaughter, reduced by the state from murder. I'm sentencing you to a term of 15 years to serve 10 with the balance probated. That will run consecutive to count 7. Counts 2 and 3 are vacated is the term we use, but they basically go away. You cannot have a sentence or a conviction for those because of your sentence on count 1. Count 4 merges into count 1. No sentence there either. Count 5 will be 10 years to serve. That'll run concurrently with count 1. Count 6 is 5 years, and I will probate that, and that will run consecutive to count 1. Count 7 I already told you about. 8 is Ms. Scott. 9 will be 20 years to serve. That runs concurrently with count 7. And count 10 has to be 5 years. It will run concurrent with count 6. That's that 5 years that has to run at the end, and that's probated. So your total sentence is 40 years to serve 30. It's what the state asked for. You'll get credit for all the time that you've been in. I did not ignore your request for a chance. This is a very serious sentence, but 2 things about it. 1, it is parolable after you serve your time for the armed robbery. And 2, it does give you a chance. It's not a chance as soon as you want it, but it is a chance as soon as I think is appropriate, given how serious this was, the loss of life, the potential loss of 2 lives. It's just fate that Mr. June didn't get shot and killed as well. I'm not saying that you were saying, I want to hit this guy versus this woman, but he could have easily been killed either during this shootout after the robbery, but more so with the big rifle that following morning. So we're all fortunate that he survived, but a woman who had nothing to do with anything and who never had a chance that night or that morning is dead. And so I think that this is a sentence that reflects a balance between Emmanuel Watson, who's a 16-year-old and maybe didn't have all the support and guidance in his life that we would have wanted him to have, contrasted with the seriousness of what happened. And so I'll say this in closing. I spent the day at the facility you'll go to first, which is the Jackson Diagnostic Facility. When you get booked in, that's where you go first to see what they do there in intake. They engage in a holistic analysis in the way that Mr. Francis was describing. They don't just see you as what your conviction is, but they're going to want to understand the opportunities you have had and hadn't. And it's where you get to say, you know what, I didn't finish high school. And so while I'm in prison, I'd like to get my GED, or I'd like to learn about HVAC, or I'd like to do this or that. And so that's the first chance you're going to get, is when you're interacting with those folks there. Let them know that I don't want to go to the place where I can run with the gangsters. I want to go to the place where I can do X or Y or Z, keep my head down. And when I am qualified to be in a lower security facility, I can go there, get to a halfway house and re-engage with my family and whatnot. So chance number 1 is coming in a few weeks when you get to Jackson. And you can be the tough guy and tell them to screw off and not answer their questions. And then they'll say, all right, we got a guy who has these serious convictions. Send him in the direction of the guys you don't want to be hanging out with. Or you can say, I've screwed up before, but I'm serious about having chances. And here's what I'd like to do. And it's prison. I don't want to make it sound like you say, I want to go play on the football team. Like, great, you go do that. But it is much more comprehensive than I thought. I sat and watched as they met with young men and old men, and not women at this facility, to figure out what makes these people tick. Where's a safe place for them to be? And where's a place where when they're done, they don't come out worse off than when they went in? Because that doesn't help anyone. If you get out and you're ready to shoot up the next pavilion place, we haven't accomplished anything. That's not my goal. That's not the state's goal. It's to make sure this doesn't happen again. Okay. Mr. Abadi, anything else in connection with Mr. Watson's case?
Your Honor, I'd like to ask that there be no contact with Elijah Hunter, Spencer June, and Durante Austin.
Okay, those will be the special conditions of probation. I'm not going to keep you away from Cleveland Avenue. When you get out, Cleveland Avenue may be a giant shopping mall, who knows? But if that's where your family is, I'm not going to keep you away from your family. But I will require that you have no contact, number one, with Mr. June, you know who that is. Number two, with Mr. Austin, I don't think I met him. That was the guy who would have been on the screen this morning. And then the third was the gentleman who was here yesterday. And that was Mr. Hunter. So no contact with those three people when you get paroled and you are back in circulation. Mr. Francis, anything else on behalf of Mr. Watson?
No, just, well, one thing, we'll do the form once we
Yes,
finish.
that's right. He's not going to go downstairs till you all complete
Right.
that. And then I'll get on the record
Okay,
the signatures. In fact, thank you for flagging signatures. Mr. Abate, you've signed the indictment indicating the state's support of this guilty plea. And then Mr. Watson, I've got your signature on the indictment.
Yes, sir.
And Mr. Francis, this is yours?
yes, Your Honor.
Okay, I'll do that same signature verification with the plea of guilty form if you'd go over that with Mr. Watson.
Okay.
Your Honor, I just want Mr. Watson to be aware that members of his family have now spent a lot of time in their home, speaking with them and talking about you. And it's clear to me that they very much love you and they hope that you realize that and you take this opportunity to really embrace that, because especially with Ms. Johnson, I spent 2 hours with her and I've never seen somebody so brokenhearted over somebody who she's not biologically related to. So I hope you remember that.
Yeah, I want to echo that. I don't know them at all appropriately. We haven't been talking, but this is pretty unique. You had 3 different sessions with family members trying to work through this with you. And I'll tell you, the saddest of sad is having a young man your age and there's no one back there. So you've got chances and you've got folks who want to help you through those chances. I don't know where they were in October of 2020, and I bet they regret they weren't right there with you. They were probably doing their best and juggling lots of other things. But I sure hope that when you get out, they're ready to lift you up. Okay. I can't let you go quite yet. Ms. Singleton.
Yes, Your Honor, I just want to place his juvenile time on the record so that he'll receive credit for that. If he can receive credit from October the 29th of 2020 through August the 19th of 2021, that was served at Metro RYDC.
Thank you. My intent was that he was to receive credit. I've got in the system that he was booked in, it may have been at a YDC, October 29th. That was his date of arrest, and he's been in continuous custody either at a YDC or at Rice Street, which is why I've been pushing lawyers to represent this guy and move the case forward. So you'll get credit for every single day from October 29th, 2020. So that clock has been running for a while, and we'll take it from there.
Yes, Your Honor, just so that the court will be aware, DOC doesn't capture the juvenile time, and so they just requested specifically states what facility. which is
Great. We'll break it out into the 2 pieces.
Yes, Your Honor.
Thank you. All right.
Thank you, Judge.
So 2 things. One, will you let the jury know we didn't forget about him? Something came up. And then I need to know what's happening with Ms. Scott.
Scott.
Judge, you did say 5 years concurrent with count 6.
Correct. Those are the 2. He cannot get 2 consecutive sentences. So 6 and 10 are concurrent and they are consecutive to 1. And that should add up to 40.
Okay, so 6 is only consecutive. Okay.
6 is consecutive to 1, 10 is concurrent with 6. Are you hanging in there? Okay.
Sleeping with the child. Even after probation. Right now, so it's okay.
So if you're pretty sure, Mr. Adams, and I'll get Ms. Scott to tell me as much, that it's going to be a plea, my thought is that I go excuse the jurors. But if it's not going to be a plea, then I'd like to get the jurors in here. They're understandably ready to roll. Sure, you should confer.
Yeah, for sure.
Yeah. Have you all let Henry County know they don't need to? Thank you. Durante, Deronte.
Yeah, right. Oh.
That's funny because I didn't answer certain questions. If we have to complete the form.
Great. Let me just verify the signatures on the record. So Mr. Francis, you went over the plea of guilty form, which basically summarizes the same set of rights that Mr. Abate did during the plea colloquy. You covered that with Mr. Watson?
Yes, I did.
He understood it?
Yes, he did.
And you've signed it on page 5 as his counsel of record?
Yes, I did.
And Mr. Watson, looks like you signed it on page 4. Is that correct?
Mr. Watson.
You signed this document as well?
Yes, sir.
All right, thank you so much. We're good.
Thank you. Okay.
All right, Mr. Adams, I need to know whether I should bring the jury out here or if you want to sign Ms. Scott up for a plea.
the nature of this business. We gotta get his clothes. They're gonna bring his clothes back up. They're gonna bring his clothes back up. Nature of this business. When I got here this morning, he was like, you just somebody. I said, oh, wow. Yeah. All that happened this morning? Yeah. Glad I missed it. Yeah. Yeah. He's like, yo, co-counsel. I ain't knew all that. Well, no, I didn't do anything. No, I'm saying, I ain't know all that. Oh, yeah. No, see, I didn't ask to see. No, but that's what we put it. Well, on certain witness. I didn't ask the same question anyway. I didn't cross that anybody. So, you don't understand. No, oftentimes, they like.
Mr. Abate, if Ms. Scott wants to move forward, which of course is her right, I'm assuming that would streamline what remains, or would you be calling, unfortunately, it looks like you let Mr. Dog Handler go.
It would streamline.
It would or would not?
Would.
Okay. I guess more importantly, would you be able to have the next witness that you'd want to call here in the next few minutes?
I had a witness.
You have a witness, and in the meantime, your team could be getting more.
Yes.
Okay, excellent. All right, so Mr. Adams, I need to know now whether we're bringing the jury in. They've now had their morning break as well to resume the state's presentation. And I'll simply explain that Mr. Watson's case is no longer before the jury, but the one charge against Ms. Scott remains in front of the jury and will proceed accordingly, or if instead Ms. Scott wants to enter a plea.
Now, if we possibly enter a new, right of refusal, or stated made a recommendation of the non-negotiating with the right to withdraw.
No, we're past that point. I guess I should add this, and I'll answer your question more directly. So you're asking to allow Ms. Scott to go forward with a non-negotiated plea with the ability to withdraw the plea if she doesn't like the sentence she gets. But that was final plea date. That's already passed. We do have two cases. Ms. Scott has a much less serious, I think it's a theft by receiving case. I'm assuming whatever we're discussing to resolve things would resolve both of Ms. Scott's cases. I don't intend to do back-to-back trials for Ms. Scott. If we're working out this situation, it ought to resolve her other case as well. So, okay, so the state will dismiss the other case. But the options are three. One would be a negotiated plea. So everyone knows what the two parties are recommending. Doesn't bind me, but is certainly informative. Two would be what just happened with Mr. Watson. So a non-negotiated plea, state recommends X, Mr. Adams recommends Y, and I figure out, am I going with Y or X or something different? Or three, we continue doing what we're doing, which is get this jury of 14 back in here and have the state call its next witness. Mr. Adams, what is it that Ms. Scott wants to do? All right, well, I'm happy to decide because silence is a not guilty plea. So let's bring the jurors back in. Okay, hold on for a sec. Mr. Adams, you want to come up to the podium?
The procedural question, John, I have a problem with something that happened just today. And I think the juror asked the same question. Mr. June was on the stand and he's asked it. I don't know why the question was asked, but he wanted to know if there's any interaction between him and Ms. Todd. He said yes. And he proceeded to say that sometime after the incident, that Mr. Scott approached him. And he was afraid, he was scared. He didn't say why he was scared. We couldn't get a definite date, but he said it might be at least a week. That was his words. It might have been 2 days or it might have been a week. That was very damaging testimony. It turns out that she was released in April, 6 months later. So it couldn't have happened. The state had no knowledge when she was released and made no effort to. We think that was a procedural misconduct. We'd ask that the case be against her, be dismissed, not passed, or at this time.
Okay, I appreciate you flagging that. I thought that actually you brought it up when you cross-examined. I'm remembering the situation. I'm not placing blame anywhere. I thought that it was initially pretty helpful for your case because it sounds like it can continue to be because it undercuts Mr. June's testimony. It sounds like he could not have encountered Ms. Scott near the mailboxes at Pavilion Place a day after or even a week after. And he didn't pin an exact date on it. You're right. He said, I don't remember exactly. I wasn't living there anymore, but it would have been a week or two after the shooting. And if Ms. Scott was in custody, then that's an impossibility. And so that calls into question his recollection, his credibility, et cetera, all things which help your case. They don't hurt the case. The state's not obligated to impeach their own witness. My sense was that they got a little nervous about him saying that. They may have known also, wait a minute, Ms. Scott was in for many more months. You're free in your case in chief to bring out the fact that Ms. Scott wasn't, it's not a secret to the jury that your client was in jail. So I find no prejudice to Ms. Scott that the jury heard that your client was in jail. That came out in opening and it's going to come out through all these phone calls. It sounds like to me, the important point for your defense of Ms. Scott in impeaching or undercutting Mr. June would be to get in front of the jury the fact that Ms. Scott wasn't released until April. And you can do that by calling Ms. Scott. You could do that by getting a records custodian from the jail. Maybe the state will stipulate to the fact that Ms. Scott wasn't released until April. And then you get to argue what you want about the believability of Mr. June's testimony, at least concerning his feelings about Red and his recollections of when he saw Red. So I'm not going to dismiss the case or grant a mistrial because of that, but I noted that it was one of the few questions you strategically decided to explore with Mr. June was, well, wait a minute, when are you saying this happened? Probably because you're thinking it couldn't have happened when you said it did. Okay.
He didn't say when it happened.
He didn't. He wasn't able to pin a date on it. My recollection is, and I'm not the jury, they'll recall, was that he certainly didn't say it was months later. He pushed back on the notion that maybe it was the next day. He was a little squishy with some of the timeline. But one of the jurors had a question about it, Blue Ink juror. And so I followed up with him and he said, nah, it wouldn't have been the next day. It would have been a week or two after because he was coming by to get his mail. I'll tell you, a week or two after is not April. So where you want to go with that, you're free to, but I see it actually being more helpful to Ms. Scott's defense than helpful to the state. And for that reason, I'm going to deny your motion.
Okay, thank you.
You're welcome. Let's bring the jury in, please. Yeah, I'm going to have you two move around so you can see the screens and everything.
On tape. Just going on the she's on the tape, walking him through how to unlock it. If you're really gonna, it only get worse for her. And it's gonna play the calls where she's talking about how much she talks to Watson. Stuff like that. I'm gonna play all those. So I'm gonna recommend a turn-in date. I'm gonna recommend that you don't go with this. You can get your affairs in order, but the judge may give you probation.
Okay.
It's up to them.
Okay.
Think of a heartfelt speech, I don't know. But you're on tape.
You can.
They've moved. Mr. Adams, you moving around? I'm right here.
Yeah, we're gonna go non-negotiated.
Okay. Well, let's do that. What I'm gonna do is get us rolling through that. I'm gonna get partway through it. Once I accept the plea, I'm gonna I'm gonna just get all the way through it. Let them know. Give me a few more minutes. All right, I need you, Ms. Scott, up at the podium with Mr. Abadi.
Right. Mhm. I work downtown at the I just started at the I forgot what it called, but it's right down there by the precinct 5. By zone 5.
What is it? What's
It's a
that?
warehouse. I forgot what it called. I just started on the 12th. And I have six kids.
All right, Ms. Rivers, you ready? Let's get on the record again. We've got Ms. Scott up at the podium with Mr. Adams. Ms. Scott, it's my understanding after wrestling with your different options, you've decided to go forward with what we call a non-negotiated plea. Is that correct?
Yes, sir.
That means that Mr. Abadi is going to make a recommendation as to the one count, which is conspiracy to commit armed robbery. It's going to be a different recommendation from what I hear from Mr. Adams. I'll weigh both those. I'll hear more about you and your situation. And then I'll impose a sentence. But the difference between a negotiated and non-negotiated is that this at least gives you and your lawyer a chance to advocate for something different than what the state is asking for. But in the end, if the sentence I give you is different from what you asked for, you understand that you are bound by that sentence. You don't get to say, oh, well, never mind then, bring the jurors in. This is a point of no return. It's either let's bring the jurors in or let's do this plea. You understand that?
Yes, sir.
Okay. With your understanding, I'm going to have Mr. Abate put you under oath. Once you're under oath, answer his questions truthfully and completely. And please let me know if you've got any questions. Will you do that?
Yes, sir.
All right. When you're ready, sir.
All right, and you solemnly swear and affirm that the testimony about the given matters coming before this court with the truth, the whole truth, nothing but the truth. Now,
Yes, sir.
you put your hand up. Could you please state your true, correct, and legal name on the record?
Shakir Nicole Scott.
And Ms. Scott, are you at this time taking under the influence of any drugs, alcohol, or medicine?
No, sir.
Is there any medication that you take on a daily basis or regularly that you've not taken today that would affect your ability to understand why you're here?
I do, but I'm not on today.
Okay, and whatever medication you take regularly that you haven't taken today, does that affect your ability to understand everything that's going on and understand why you're here?
Yes, sir.
How old are you now and how far did you go to school?
32. 32.
How far did you go to school?
11th grade.
And are you able to read, write, and understand the English language?
Yeah, I have a learning disability, but I can understand if you tell me.
Okay. And do you understand that you are charged in indictment number 21 SC 178032, which is count 7, a single count of conspiracy to commit armed robbery?
Yes, sir.
And have you had enough time with your lawyer to speak about the facts and circumstances of the case and the right you'd be waiving by entering a guilty plea today?
Yes, sir.
And are you satisfied with the services that your attorney, Mr. Adams, has provided?
Yes.
Mr. Adams, do you waive formal reading of the indictment?
We do.
Do you also waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this plea?
We do.
And Ms. Scott, has your attorney, Mr. Adams, advised you of the minimum and maximum sentence for the single charge you're pleading guilty to?
Yes, sir.
Did he advise that the minimum is 1 year, the maximum is 10?
Yes, sir.
And you understand this is a non-negotiated plea of guilty, which means the state will make a recommendation, and then you and your counsel will have the opportunity to address the court and also make a recommendation. And the court is not bound by the state's recommendation or by the recommendation of your counsel. The court can sentence you as he sees fit on the single count of conspiracy to commit armed robbery.
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, sir.
And just to back up, and I apologize, as it relates to the non-negotiated plea, you understand once the court accepts your plea that there in sentences, there's no ability or right for you to withdraw your plea after it's been accepted.
Yes, sir.
Now, do you understand that you waive any and all defenses by entering a plea of guilty?
Yes, sir.
And do you understand that by pleading guilty, you will list a number of rights? You're giving up those rights. And they are the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or appointed if you were unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after trial. Do you understand that you're waiving or giving up all of these rights by entering a guilty plea here today?
Yes, sir.
And Ms. Scott, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today? Yes,
No, no.
Okay. And is it your decision to waive these rights and enter a guilty plea because you're in fact guilty now?
Yeah, if we could, we haven't talked to the state, we'd like to enter this under North Carolina versus law.
All right.
So Ms. Scott, are you pleading guilty because you decided that it's in your best interest to do so?
Yes, sir.
And are you aware that even if you don't admit to guilt, that this plea of guilty, that this is a plea of guilty and it places you in the same position as if you were convicted by a jury at the trial of your case?
Yes, sir.
And how do you plead to the charged single count of conspiracy to commit armed robbery, which is count 7, and indictment number 21 SC 178032?
Guilty of law. Yeah, guilty.
Yes, sir.
Guilty under offer?
Yeah, on the offer.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Lastly, did Mr. Adams explain to you, do you understand that you only have 4 years from today for a felony charge, which your single count is, to file a habeas corpus petition challenging this guilty plea? Do you understand that?
Yes, sir.
And you have had an opportunity prior to now to discuss with Mr. Adams what a habeas corpus petition is and your rights as it relates to challenge the guilty plea for voluntariness.
Yes, sir.
Do you have any questions at this time about that?
No, sir.
Your Honor, have this case continued to proceed to trial. The state has been able to prove beyond a reasonable doubt that prior to October 19th of 2020, on multiple occasions, but on specifically October 18th of 2020, Ms. Scott, who was in custody, who had been arrested on October 9th on an unrelated charge to this case as it relates to possession of GSA, possession of certain types of drugs. She was in custody continuously from October 11th into October 20th for this case, for the charges in which this case relates to. And on October 18th, Ms. Scott called her own cell phone that Mr. Watson was in possession of. And during that conversation, about 4 minutes into the call, you hear the defendant, Emmanuel Watson, ask if she would be mad if he robbed June and them. And they had a conversation about that. And they both identified that they were talking about the same person. The person who lived in the apartment behind where they were staying. They continued to talk about Mr. June as well as the relationship they were in. It was clear from not this call only, but from multiple calls preceding this call on the 18th that Miss Scott and Mr. Watson were in a sexual relationship. There were a lot of conversations that were graphic as it relates to that, further proving the identities of both parties. They go on to talk about the fact that, yeah, I'm talking about the old man who lives with the grandma, and they decide as they talk that that would be something that would be beneficial to both of them as she was in custody and wanted to get out on bond. During the call, Ms. Scott advises and tells Mr. Watson that to be sure to have something covering or on your face. You want to walk up to him and ask for the weed because he's not going to have it on his person. It's going to be in his house, which will be beneficial to you because he will take you into the house to get the weed. And at that point, you'll be able to rob him for everything. You'll be able to walk into his house and rob him for everything he has. At that point, they decide that it is a pretty good decision as it relates to the plan that they have concocted as it relates to getting some money and being able to hopefully get enough money to pay the bond to get Ms. Scott out of custody as it relates to her arrest on October 11th, 2020. As your Honor is aware, through the facts that you heard yesterday as it relates to Mr. June, that armed robbery was a substantial step, and the completion of the armed robbery by Mr. Watson actually occurred on the next day, October 19th, 2020, early in the morning, where the defendant, Mr. Watson, was identified positively by Mr. June in the suspect photo lineup, assisted and participated in holding Mr. June at gunpoint and taking belongings that he had on his person, specifically the wallet, cash, and credit cards, along with a firearm as described yesterday by Mr. June. Had the case proceeded to trial, we would have been able to and did show that the state's going to be on reasonable doubt.
Did the phone calls, did Mr. Watson in the phone calls talk about taking just the wallet or wallet and gun?
Well, in the afterwards, so prior to it was just that it was the.
Oh, no, after. I mean, he didn't know he'd have a gun. I'm saying because there were clearly discussions afterwards, according to you, because Mr. Watson was talking about, I shot up the place and now the police are, he's laughing. But at some point after the I'm just wondering for corroboration, nothing to do with Ms. Scott's case. Just curious what the jury would have heard. Did Mr. Watson ever say, not these words, not only did I get his wallet, but we got a gun out of it too?
He did. They referenced that, and that was a gun they sold. They sold that gun as it related to what came off Mr. June.
Okay.
We talked about that was one of the guns that he was able to fire towards
Mr. June.
Yes.
Okay. All right. Thank you.
I don't believe Ms. Scott has any felony convictions, and if she has felony arrests, I don't have to sign in my computer. But if she does, they're very minimal from what I recall. They are minor theft type cases, like the one that she's charged. The second case Your Honor has before in your courtroom. So the state's recommendation based on the seriousness of what occurred on the 19th and what happened because of what occurred on the 19th into the 20th is 10 years to serve, 5 years with balance to be probated. The state has absolutely no issue with the turn-in date. That's 30 to 60 days from today based on seeing Ms. Scott has a newborn baby and then just other children at home in order to get her affairs in order. And the state's, as part of the negotiation, the state has agreed to, by taking this non-negotiated plea, no cross. Second case, and I don't have the case number before me.
No, I don't. I'll look for the calendar, but it's on the calendar. It was the second case of Ms. Scott's on our trial count. I've got it right here. It is 22 SC 183372, in which Ms. Scott is charged with theft by receiving, misdemeanor, felony theft by receiving, misdemeanor obstruction, and fleeing or attempting to elude. 2 misdemeanors, 1 felony. That's the case that you'll dismiss, assuming this plea goes through. Understood. 10-5 balance probating. All right. I'm curious if Ms. Scott had agreed to assist the prosecution of Mr. Watson. Was there a different offer? It's always been 10-5, or what? If you want to disclose, that's not.
I can definitely disclose. We hadn't really gotten to the point of discussing, she, through her counsel and actually through speaking to her, permission from her counsel, she had agreed to assist the state as it relates to testifying against Mr. Watson, if and when that time came. What I would say is that due to the lateness of the agreed upon testimony, we were unable to really go through the jail calls with Ms. Scott, so she could kind of have a come to Jesus moment with all the things that were said. And I will say, in all candor to the court, that is not Ms. Scott's fault. I blame it on Mr. Adams' lack of how to work technical things.
Okay. I won't hold that against Ms. Scott, but it doesn't sound like, I mean, this case has been on calendars before. I've been kind of surprised. It's not my call, though, that Ms. Scott wasn't sort of in the vanguard saying, let's work these things out. And that didn't seem to be her posture. It sounds like it was only more recently that through Mr. Adams, you learned that she was willing to acknowledge her voice on her phone calls with Mr. Watson.
Yes, up until this week, it had always been indicated to me, she had indicated on several Zooms and in the court that no jail calls, no such jail calls existed.
Okay.
But I think in the short time that we've all actually been able to have a cocktail, a me conversation, she has changed her tune as it relates to some of the things that the reality shows.
Okay. Mr. Adams.
Yes, Your Honor, the reason we request an offered plea is I've listened to the tapes. Most of what I heard was Mrs. Watson saying what happened. She discussed a little bit. I didn't hear where she planned it or anything. The indictment says that how she had made this thing was that someone asked for the marijuana. That did not come out on trial. She was concerned about some of the voices on the tape. Hearing how the robbery was supposed to be planned, it didn't happen that way. He's supposed to knock on the door. He did not. He was asked to come down. But she still wants to resolve this case. She's has 6 kids. Those are 17. The youngest is 3 months. She is employed. She did know Mr. Watson. But like you say, she was incarcerated until April. You know, you ask her, like she has the 1 kid, as far as whether she's willing to testify, we've advised her more than 3 months ago. And we just didn't know what he wanted to hear. She told him she would testify that it was Mr. Watson's voice.
He brought me probation.
He did recommend, didn't guarantee it, but he did talk to her about probation maybe. Based on all that, we would ask for 5 years probation.
All right. Ms. Scott tell me what medications you take when you do take them.
Like I told you, I have a learning disability, but I used to be on Xanax, and I was on that back then. I was on that real bad, but they took me off on. Right now I'm on Adderall 30, and it started with a C. I forgot what.
Okay, the names don't matter so much as what do they help address?
I got one on to help with my bipolar, my ADHD, and my sleeping disorder.
Okay, but you did not take them today?
No, me and my kids they take them too. We have a follow appointment coming up.
Okay, when did you last take your medication for bipolar?
Last month it was on the 13th.
Do you take it just once a month?
No, we take it every month. You know, you go to the doctor once a month.
Okay.
That's when he prescribed. I would tell you when he prescribed, and my last day of taking it was last month.
Okay. What about the ADHD medication? When's the last time you took that?
I don't have no more right now. We're going to our appointment coming up.
Okay, so you've run out of all those medications. Have you had any difficulty understanding what we've been talking about today?
I understand it.
You understand it? Okay, any questions about what Mr. Abate's been saying or Mr. Adams has been saying?
It was stated to me that what was gonna happen, and yeah, I was talking about it. I was having a conversation like I went in my right state of mind anyway. If I wouldn't be talking on the jail phone.
Okay.
But,
so my question isn't do you agree with it or disagree with it, or do you have an explanation? Did you understand what he was saying? It sounds like you understood what he was saying.
Yes, I understood what he was saying.
Okay. All right. And you mentioned you've got learning disabilities.
Mhm.
What are those?
I read the problem.
Okay. I don't think you've had to read a whole lot to move forward with what we're doing today. Mr.
Yeah.
Adams has helped you with that?
Mm-hmm.
Yes?
Yes, sir.
Okay. All right. An offered plea is when a defendant says, I don't agree with everything the state says, and you were starting to get into that. So, like, Eric, I was on these phone calls, but it was more Mr. Watson talking, and I was just listening. An offered plea is when a defendant says, I may not have done everything the state says I did, but I still want to work this out with a plea rather than have the jury decide my case. Does that describe your situation?
Yes, sir.
All right. You understand it's still a conviction.
Yes, sir.
All right. I need, Mr. Abate, if you pop back up here. Well, actually, Deputy Gordon will bring it to you. We ran out of printed areas to sign, so Ms. Nelson put a stamp down over on the left-hand corner. If you'll sign, not the one that I wrote guilty next to. Yeah, if you'll sign for the state.
I just tried.
Ms. Jones-Connor was able to assist me with the felony convictions prior for Scott. She has two prior, one theft by shoplifting and one theft by taking 2012 and 2015.
Okay, as far as you can tell, they're closed. We don't have a probation revocation issue.
We're gonna double check, but
Okay.
I remember looking at 2012 when that one really is closed for sure.
Okay. All right. So did you two both sign and I'll wait for you to sign down at the very bottom where it says defendant. All right. Ms. Scott, what case were you in custody on when all this happens? You're in jail on these calls. What were you in jail for?
I was in jail for, I had to run a car and I ain't take it back on time.
Okay.
So there was, I guess that, and then I was in there, then they put another charge on me, so I stayed in there longer.
And you eventually got out in April?
Yeah, I got out in April, yeah.
Okay.
2021.
When did you get arrested for this, or was that the charge they put on you?
Yeah.
So when you got out in April, you had been spending some time trying to get a bond on this case?
Right.
Okay.
Well, they put them together, I think.
They put them together. All right. I think we've covered that. You signed. All right. So what is you probably said this and I missed it during your presentation, Mr. Abadi. What is the range for conspiracy to commit armed robbery?
1 to 10, which was interesting because
Yeah.
attempted armed robbery is 1 to 30. But
Right.
1 to 10.
1 to 10, it is what it is. All right. So Ms. Scott, I appreciate you sharing with me how you were doing at the time and saying you weren't in your right mind, you weren't on your medication, et cetera. I do find there's a factual basis for your plea that if we brought the jury back in here and they heard all those phone calls, that they could conclude that you conspired with Mr. Watson to rob Mr. June. That doesn't mean you robbed him. I mean, you had a gun on you, but it means that you influenced Mr. Watson to do it, and he did it, and it was something that you two had planned. Not that you tried to talk him out of it as the adult in the relationship, but that you said, hey, what you need to do is get on inside that apartment. You don't want to just jump him on the outside. And I appreciate Mr. Adams pointing out it didn't go down that way, but that doesn't mean you didn't assist in planning what happened. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one is forcing you to enter this plea. You've decided that entering an offered plea is a better outcome for you than continuing on with the trial. So I'm accepting your plea. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a small problem with probation, like maybe you fail to report, you and probation will work that out. You don't have to come see me. But if you get arrested for anything, that comes back to me. Or if there's a more serious violation, that comes back to me. Ms. Scott, I am going to sentence you to a term of 6 years to serve 1 year with the balance on probation. You'll get credit for the time that you've served. I'm going to give you a reporting date of February 26th. You will need to be here in this courtroom by 9 a.m. If you are not, then the sentence that I sign is going to be 10 years to serve 4 years with the balance probated. So your sentence that I'm sharing with you today is 1 year in custody, credit for the time you've already done, followed by 5 years probation. If you're not here on February 26th to turn yourself in and you come here to this courtroom, you don't go to Rice Street. If you come here, if you're not here and Mr. Adams isn't running interference for you saying, hey, she's on her way, the sentence that I'm going to sign is 10 years to serve 4 years. So you will have quadrupled the term of custody because you didn't show up. I wanted to give you a little bit of time to arrange your affairs, and that's the time you're going to get. A special condition of your probation is that you have no contact with Mr. Watson while you're on probation, so don't call or write him while he's in custody. No contact with his family, and you also have no contact with Mr. June. Was there anyone else you'd want Ms. Scott not to have contact with, Mr. Abadi?
There you go.
Okay.
Well, actually, I would have no contact with Miss Jeffrey Alfred. I think it probably wouldn't be healthy.
Okay. So no contact with Ms. Alford, also known as Star. I think that's it, because it was only one count, and Ms. Nelson will sort through the time that you did. It sounds like it'll be a few months when the new charge was put on you while you were in custody for the old, and the state is dismissing 22 SC 183372. Mr. Abadi, anything else in connection with Ms. Scott's case?
There you go.
Okay. Mr. Adams, any questions or concerns about Ms. Scott's situation?
No, yeah.
Ms. Scott, do you understand when you need to be back here?
You said February 20.
February 26th. How is she going to get notice of that besides me just saying it?
I got an address.
Okay. We'll publish a calendar, so you'll get something. Have you been getting stuff in the mail? Then you should let us know what a good address is for you, and we'll get a change of address. But I'm telling you here in court, and you're going to leave with a piece of paper that says February 26th at 9 a.m. So that's when you'll need to be here. Don't bring lots of folks with you. Don't bring your kids with you, and don't bring a bag of luggage or anything like that. Just come in real basic clothes. February 26th. Once you write the correct address on there, if that's hard for you to do, make sure Mr. Adams writes the correct address on there, okay?
Okay, and then do I get, cause I did how long in jail, so.
Yeah, that'll be taken care of. Someone's gonna look at how long you were in jail and you'll get credit for that against the year you're serving.
They gonna show me like.
Yeah, they get it.
That'll all be documented.
Mhm.
You gotta sign that.
Right here.
All right.
That's it.
Yeah.
Yeah, 1, 2,
24.
Mr. Abadi, anything else for the state? Compton Drive?
Yes, sir.
Okay, and it's not an apartment, just that number. It's a house?
Yes, sir.
Okay. Mr. Adams, anything else on behalf of Ms. Scott?
So, y'all,
All right, thank you all for your time.
thank you.
Do I wait right here?
Yeah, if you wait right here, we're gonna print out that court notice, so be hand delivered to you. I'm gonna go back there. And I'll come back out here. Do you want Mr. Abadi to take all that evidence back? Okay. I see Mr. Rao shows up just in time to do nothing.
Do you think the pictures were smoother this time?
Yeah, well, it's clearly the operator. Interestingly, I had our tech people show up for after lunch and it worked smoothly. I said, look, your vaunted fix didn't work. A half hour into it, everything fell apart. And so they were here, including the boss, and it worked. They're like, can I leave now? Sorry, it's working.
I think it's good.
I'm gonna turn off the YouTube piece. Hold on one sec.